of that mediation process. Of course, in the context of the courts of law, you can appeal that decision until to the apex court in the country. Yeah. Then what happens? Is there an appeal mechanism in the alternative or the appropriate dispute resolution mechanism in the event a party feels continuously aggrieved and that matter isn't settled by the third party?
Well, the thing is that you have to appreciate that when you go to mediation, there is no compulsion to settle in mediation. You don't have to agree. If you're dissatisfied with the potential outcome, you walk away. Yeah. And that's the beauty of it. You walk away, but that doesn't mean that it's a spring door to some abyss. It means you can go back to court. Okay. Yeah? Now, when you go to arbitration, as you recognized, is quasi-judicial. Yeah. If you're unhappy with the outcome of it, again, you can go back to court. Now, what it does, though, is to set out very narrow parameters within which you can go back to court. Because the policy of the law is you chose to go to arbitration. You understood what the tenets of arbitration were. If you were dissatisfied, then as a court, we will only entertain you on some very narrow grounds which are set out in law. When you go to conciliation, conciliation by its very nature and the term of it is to reconcile. Yeah? That means it's in your hands. So the whole purpose of this is really to put the tool in your own hands. And you don't have to be thinking or worrying about resort to appeal or resort to some other framework through which you can challenge any of these mechanisms. And really what we're talking about here is moving a large majority of our disputes from this formal framework. Yeah. And the thing about the court system you have to appreciate is the law says how many judges we can have in this country, how many judges of appeal we can have, how many judges of the Supreme Court we can have. There's no law that says we can only have X number of mediators. So that means mediation is scalable. There is no law that says we can only have 2,000 arbitrators. So that is scalable. So as demand rises, the number of resources also rise to meet that demand. Yeah. So in that sense, it becomes a system of justice that really essentially frees the judiciary to deal only with those cases, the most complex cases that they need to apply their minds to, they need to apply the law to, and be able to resolve in a way which the law recognizes.
And Prof, as I pose this to you as a law professor.